So Ms. Montgomery, I'm going to accept the recommendation for probation, but what I need you to understand is I don't care whether you say you did it or not. You pled to this thing. You've taken responsibility for it.
Welcome back to our Chanel, where today's case takes us deep into a heated battle over words, threats, and the consequences of a single phone call. At the center is Miss Montgomery, a healthcare worker and aspiring student with her future on the line. The charge? Misuse of telecommunication services, a fancy legal way of saying she allegedly used the phone to harass, threaten, and even drop terrifying threats about burning down someone's home and harming children. Pretty shocking stuff. But here's the twist. Montgomery insists she never even made that call, yet still took a plea deal on the advice of her lawyer. Why would someone admit guilt to something they claim they never did? Was it legal strategy, bad advice, or fear of facing trial? Stick with us, because the judge's reaction to her explanation, the strict probation conditions, and the staggering list of financial penalties make this case one you don't want to miss. Let's get into it.
It's set for sentencing. The court has had an opportunity to review the pre-sentence report. With respect to the report, are there any additions, deletions, or corrections on behalf of the people?
Yeah, there is a minor correction on page 1 under the original charge. It should be telecommunication service, malicious use. The final charge is attempt telecommunication services, malicious use.
All right.
And nothing else on behalf of the people, Judge.
Any additions, deletions, or corrections on behalf of Ms. Montgomery?
No, Your Honor.
All right. Anything with respect to sentencing on behalf of the people?
Your Honor, looking at the recommendation for a 12-month period of probation, I'm asking the court to adopt the recommendation from the probation department. I see that they also recommended 12 weeks of anger management, which is fine, Your Honor. Other than that, I have no other.
So right off the bat, the prosecution is keeping things simple. 12 months of probation and anger management classes. Now, anger management might sound like a check-the-box requirement, but legally it's serious. Courts often use it to address behavior they believe could escalate into violence. Remember, the original complaint alleged threats to burn a house and harm kids, words that, if true, could have devastating implications. Question for you all, do you think anger management is a fair consequence here, or just the court overreaching for control? Drop your thoughts below.
Nothing else on behalf of the people.
Ms. Montgomery, I need you to adjust your camera so that your full face is in the camera. All right, thank you. Counsel, anything on behalf of Ms. Montgomery?
Yes, Your Honor. We're asking that this case be considered for delayed sentencing, Your Honor. My client is attending school. She is also asking for some reduction in the fines because she's unable to pay the fines requested financially, Your Honor. She has aspirations to higher education, and we're asking that this court will consider delayed sentencing, allow this matter to be dismissed if she completes those requirements, Your Honor.
Here's where the defense plays strategy, asking for a delayed sentence. What does that mean? If Montgomery stays out of trouble, meets court conditions, and shows progress in school, the case could be dismissed after probation. It's basically a second chance, a legal reset button. But she's also asking for reduced fines, saying she can't afford them. Judges hear this request all the time, and sometimes financial hardship does sway decisions. But let's be real, how often do you think courts prioritize someone's pocketbook over their rules? Would you cut her a break or hold the line?
Anything else, counsel?
No, Your Honor.
And would Ms. Montgomery like to make a statement on her own behalf?
Yes, Your Honor. Your Honor, thank you for allowing me to speak today. And I would like to tell you that I've always been a productive member of society, and I have a full-time job in the healthcare field, and I also have an associate's degree of Associates of Arts in Business from WC3. I've taken a plea under the advisement of my attorney, and I would like to apologize for being here today. And also, as regard to the alleged victim, there's was never an there will not be an issue with contact because there was never a personal or a professional relationship. And I just ask that you just take mercy on me, Your Honor. And thank you.
That was Montgomery's chance to speak, and she went all in. A heartfelt apology, highlighting her job in healthcare, her college degree, and her aspirations. She's painting herself as a productive citizen, hoping the court sees her as more than just this charge. But did you catch the contradiction? She says she's sorry, but also claims she doesn't know the alleged victim and never threatened her. That tension between denial and apology is a major red flag for judges. Viewers, what do you think? Is she genuinely remorseful, or just playing both sides to escape punishment?
All right. I have a question before I proceed. Ms. Ritter, did this start out as a felony or was that originally a misdemeanor?
It's originally a misdemeanor, Judge.
Okay, so that means I took the plea?
Correct.
Okay. All right, so a couple of things that is concerning me this morning that I'm going to address. Had an opportunity to review the pre-sentence report. I do see that there was a no contest plea taken. And then when I look at page 4, when I first read the police description of the offense, says that the complainant stated that she received a phone call from the defendant and a heated argument ensued. The complainant said during the argument that the defendant threatened to burn her house down and kill her children. The complainant said that she has an active child protective case against her now because of the defendant calling and making false claims against her and her children. That's the police description of the offense.
This is where the case takes a dramatic turn. The judge reads the police report, chilling threats about burning down a house and harming children. Then, the defendant's version, I don't even know this lady. Talk about two completely opposite stories. And here's the kicker. Montgomery already pled no contest. That means she accepted punishment without admitting guilt. Legally, it's treated like a guilty plea. So why is she still insisting she's innocent? This contradiction is making the judge visibly uneasy. Imagine being on the bench. How would you handle a defendant who pled guilty but still denies the crime?
So then I go down to the defendant's description of the offense. And the defendant's description of the offense says, on the day in question, I was at work. I never talked to the complainant on the phone, nor threatened her. She is lying. And then a little further down, it said, the last sentence, it says, I don't know this lady, and I never threatened her. And then today, when the defendant made her statement, she said, and I wrote it down, that I took a plea on the advice of my attorney. Now, I asked if it started out as a felony or a misdemeanor because I needed to know whether or not I took the plea. And on the day that I took the plea from Ms. Montgomery, I'm going to tell you what happened. You all said that Ms. Montgomery wanted to take a plea. And then I said, okay. And then I told Ms. Montgomery, I'm going to share my screen. And on my screen, you're going to see your constitutional rights. And then I said, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights? And then I don't remember what answer she gave, yes or no. But whatever answer she gave, at a minimum, I then said, do you understand that this is a misdemeanor? And you have a right to a trial. However, if I take this plea from you today, you will be giving up your right to a trial. And then she would have said yes, because that's the only way I would have moved on to the next part. So then she said yes. And then I said, has anyone threatened you in any way or promised you anything to get you to enter this plea today? And then she would have said no, because that's the only way that I would have moved on. So I was a little, perplexed.
The judge isn't holding back now, basically saying, why would anyone plead guilty to something they didn't do? And that's a fair point. Pleas are final. They carry real consequences. Yet Montgomery claims she only did it because her lawyer told her to. This is courtroom gold, because it raises the issue of whether defendants sometimes feel pressured into pleas even when they maintain innocence. For you watching, here's the question. If your lawyer told you to take a plea deal you knew was false, would you do it to avoid trial, or would you fight all the way?
When she said, I took this plea on the advice of my attorney, and I don't know this person, and I never seen this person, or I never talked to this person. Now, something is amiss, okay? Something is amiss. And a person who says they have aspirations of going, professional aspirations, I don't think that person would take a plea to something that they didn't do on the advice of their attorney, and risk having a criminal record for something they didn't do. Especially in a situation where, as I'm reading the pre-sentence report, it appears that if the matter had proceeded to trial, I don't know if the telephone conversation was recorded. I don't know if there's a recording of the telephone conversation. I don't know if someone else heard the telephone conversation and therefore there's another witness to this conversation. Because if I didn't do something and it's on the telephone, I would be 1000% sure that there is no recording, that there could not possibly be a recording, because I didn't say or do what they accused me of saying or doing. So I said all that to say this. You can speak denial from your mouth. You can say, I didn't do it, but I don't know, but I just took a plea because my lawyer told me to take a plea. And if that's what you did, that's foolish, because your lawyer not facing jail. Your lawyer not facing a record. And then why would I take a plea on the advice of counsel if I know that I didn't have a conversation, and therefore I know that there's no possible way that there's any proof that I said what I said? There could not be, like I said, a recording. There could not be a witness to the conversation because the conversation didn't take place.
This was the tough love moment. The judge lays it out crystal clear. Probation is a privilege, not a right. Fail to follow the rules, skip a drug test, break the law, miss payments, and it's straight to jail. No second chances. It's one of the harsh truths of the justice system. Probation often feels like walking on a razor's edge. For Montgomery, this means every month, every test, every report counts. Do you think she'll rise to the challenge, or is she already setting herself up for failure with all the excuses?
So, Ms. Montgomery, I'm going to accept the recommendation for probation, but what I need you to understand is I don't care whether you say you did it or not. You pled to this thing. You've taken responsibility for it. And I see in the pre-sentence investigation that on 2 occasions you did not submit to a drug test. You came to 36 District Court, and for whatever reason, you were not able to successfully submit to a drug test. They told you to go to Affordable Testing Center, and you did not go. Let me be clear. Let me be clear. The things that I'm going to say to you today as to what you need to do on probation, these are not optional. I'm not asking you, do you want to do them? You either want to do them or you want to go to jail. That's how that works. You either want to do them or you want to go to jail. Now, I don't know why you didn't go take that drug test, but you better hurry up and go take it. You better hurry up and take that drug test. Put your hand down. It's my turn. I asked you, did you want to say anything? You better hurry up and take that drug test as soon as I put in this order. And then everything that I order you to do, you need to do it because you need to understand this. Probation is an alternative to jail, and jail is an alternative to probation. This is a misdemeanor. It is punishable by some number of days in jail that I'm not aware of, because now she's pled to attempt. And then it's punishable by some number of days in jail and up to $500 in fines plus costs, and up to either 2 years or 5 years probation, depending on the jail term. Okay, so I am going to accept the recommendation for a 12-month probationary period. And I'm looking at her criminal history, and it is nothing with respect to her criminal history, nor this specific charge that would say to me that she does not qualify for the delayed sentence. So I am going to also accept the recommendation for the delayed sentence. Therefore, at the conclusion of the probationary period, if you successfully complete probation, then the matter will be dismissed and removed from your record.
Here's a huge win for Montgomery. The judge grants the delayed sentence. If she completes probation without slip-ups, this entire case disappears from her record. That's massive, especially for someone working in healthcare or pursuing education, where a criminal record could derail her career. But the judge also made one thing clear: this deal only works if she fully commits. Any sign of resistance, any slip, and she loses it all. It's a high-stakes gamble. Would you trust someone who already contradicted themselves to handle this responsibility?
But if you come and approach this probation from a standpoint of I didn't do anything and I pled to something that they barely probably had proof of because somebody told me to, that don't even, again, that don't even make sense to me. But nonetheless, you did that at the advice of your counsel based on the evidence that was going to be presented against you. The 12-month review date will be Tuesday, June 25th, 2024. The court is going to set a midway review for, well, not quite midway, but 1, 2, 3, 4. I'm going to set a review for October the 26th. At 1:30, let me just double check. Yes, at 1:30. on Zoom, and you have the following terms and conditions of your probation. You shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without the consent of this court. You must make a truthful report to probation on a monthly basis, and you must notify probation immediately of any change of your address, phone number, or employment status. You will pay the following fines, costs, and fees. You are going to pay $210 mandatory cost, a $300 fine, no restitution, oversight fees at $35 per month for a total of $420, and a $35 pre-sentence investigation fee. The total fines, costs, and fees are $933. You do have the duration of the probation to pay that amount, but you cannot be discharged early from probation unless you have paid the full amount minus whatever oversight fees are remaining. So if you, if you get discharged at 6 months, you would have had to pay $723. You shall not use or possess any illegal substance. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not drive without a valid driver's license. You shall submit to a mental health evaluation. You shall submit to random urinalysis at least once per month. You shall have no contact with Brianna Major. There's a recommendation for 10 days of community service. I'm going to reduce that to 4 days of community service for an equivalent of 32 hours.
And there we have it, 12 months probation, strict financial obligations totaling $933, mandatory anger management, mental health evaluation, random drug testing, no contact with the alleged victim, and community service. In exchange, if she follows the rules, she walks away with a clean slate. This case highlights a courtroom reality. Sometimes the biggest punishment isn't prison time, but the pressure of living under constant legal supervision. Montgomery got her second chance. Now it's up to her to keep it. What do you think? Fair outcome or way too lenient? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.